Welcome. Today we're going to be talking about data protection from a member-based organization's perspective. We're going to be looking at what it is that you as a member-based organization needs to be considering from a data protection perspective, how you can protect personal information in your organization, what the big trip-up areas are going to be for you. And one of the things that I would just like to point out to begin with is that when considering member-based organizations, we came across the reality that member-based organizations can have a varying degree of types and scopes. You have professional associations, you have trade groups, voluntary associations, clubs, and there are many other different types. And with each of these different types comes a different particular kind of focus area, a different kind of information that is being processed, a different quantity of data subjects whose information is being processed. And so with those variables, data protection changes. What you need to do, what is reasonable for you to do changes. And that's something that we need to be aware of. And so this makes it a little bit difficult from our perspective to be able to give you a one-size-fits-all solution, to be able to say that because you're an MBO, this is what you have to do and this is what you don't have to do. It's not really possible for us to do that because of all of these variables. So in light of that, what I would like to do is I would like to run a few polls to just get an understanding of who it is that we are currently talking to. So Jade, if you could put up the first poll, I'd like to just find out what is the size of the organization that you represent. The poll should have three positions there for you. Fewer than 50, between 50 and 250, 250 more. Now these are employees; they're not members specifically. That is a second poll that we're going to be running. Okay, so we've got numbers coming in now. Looks like the majority of you are fairly small organizations. 0 to 50, that's about 61% of you. We've got about 20% sitting in the medium-sized organization between 50 and 250 employees, and similar around about 25%, but 20% sitting at more than 250 employees. So that's a decent spread, but it does confirm what I was suspecting, that a large percentage of the member-based organizations that we are dealing with are fairly small organizations. The next poll then is, Jade, if you could show the second poll, which is the number of members in the organization. So how many members do you deal with? Is it very few, 0 to 100, medium amounts, between 100 to 1,000, or getting up there to a large number of 1,000 to 10,000? Or are you dealing with a significant number of members? So it looks like we're dealing with roughly 40% of 0 to 100 or 100 to 1,000, and smaller numbers, say about 12%, around about 1,000 to 10,000, and 10% of 10,000 plus. So again, we're mainly looking at fairly small organizations, fairly small, relatively small number of data subjects that you're concerned about. But we will touch on a little bit of the factors to consider if you're a larger organization as well. And then the third poll that I'd like to raise, Jade, if you would, is the kind of MBO that you are. What kind of a member-based organization are you? Are you a professional association, a trade group, a voluntary association, a club, something else? So professional associations would be things like the South African Institute of Lawyers. Trade group would be a little bit different, more of a particular industry than a particular profession. So a group of associated professions, I suppose. Voluntary associations would be things like groups of like-minded individuals, particular religions, particular interest sects, things like that. Okay, so we're mainly professional associations. sitting at around about 40%. Voluntary associations, close second at around about 30%. And clubs and other are sitting at around about 15 to 20% over there. So I'd be very interested to see what the other bracket is. So if you could put that information in chat, that would be very useful to us. It might be that we are using different terminology or different ways of describing your organization than the one that you were used to. And it might be that, in our opinion, you fall into one of the previous categories and it's just semantics, really. But it would be interesting to see the difference and distinction there. Great. So thank you very much for all of that. Before we get into the meat of what it is that we're going to be doing today, one thing that I would like to point out is that today isn't about solving data protection for MBOs. I'm not going to be able to give you a magic wand in the next 50 minutes or so that you'll be able to wave and go, boom, POPIA, GDPR, every data protection law that you need to worry about, not a problem. Unfortunately, like I said, it's not a one-size-fits-all thing. There's a lot of stuff that we need to deal with. So what we're going to be doing today is we're going to be looking at our data protection presentation that we have run for many different organizations in the past, many different avenues and contexts in the past. Some of you may have witnessed this already before. But we don't want to just repeat that presentation because it's not going to add value to you if you've already seen it, and there's too much to deal with in the space of an hour. So instead, what we're going to be doing is we're going to be acting like a tour guide. We're going to be walking you through the city of data protection, and we're going to be pointing out for member-based organizations exactly what it is that you should be looking at. You don't need to look at this building because it's probably not applicable to you, but I know that you are going to enjoy looking at that building, or you have to look at that building. Okay. After this presentation, what we're going to do is we're going to send you a PDF of the landing page of our members, not our members organization. Okay, sorry, that was a step back and start that sentence again.
John raised his hand, Kevin.
John, save me.
Sorry, no, not to interrupt you, but I just wanted to reaffirm what you're saying is that data protection and protection of personal information is such a vast topic. And for those of you who don't know, how we've tried to contextualize that for different audiences is through the creation of lenses. So it's a little bit like having glasses and you put on a specific lens to look at the topic from a South African perspective, but you can look at it from many perspectives. And I see in the chat box that many of you are nonprofits. And so if you think of being a nonprofit or a homeowners association, you're going to look at it through a lens of the nonprofit, through the lens of being a small business, through the lens of being a membership-based organization. And that's quite confusing, but we're really trying to cater for different audiences through these different lenses. And I think today what we must really try and focus on is give the audience some key insights and possibly some quick wins that relate specifically to smaller membership-based organizations. But there is a variety, as we've already seen, of who's on the call, so it's quite tricky, but that's, I think, part of what we must try and achieve today.
Great, thank you very much, John. And then to end off really the intro part is that we'll be sending you a PDF later of our Michalsons Data Protection Compliance Program landing page that is accessible to our members. And that landing page will be focused on member-based organizations. So you can have a look at what we've written there, get some use out of that. If you find it enjoyable, please click through the relevant links, and you can subscribe to the program and see what more is available there for you to add value to your organization. Okay, so to begin with, then let me share my screen and show you the presentation that we have. And you should be able to see the presentation here in front of me. And what we're going to be doing is we're going to start off by looking at the introduction to data protection law, looking at the core concerns that we think member-based organizations or are relevant to member-based organizations. So the first step really is to consider why we care about data protection law. It's really from the perspective of protecting people from harm. We're wanting to protect our customers, in this instance for MBOs, our members who are our data subjects. Sometimes our employees are also data subjects, or our employees will also be data subjects. We're looking to protect them from harm. And the way that we do this is by identifying the kind of information that we are processing of them. And the tricky thing for MBOs is that depending on what kind of an MBO you are, what kind of an industry you're involved in, you could have a wide range of different types of personal information that you process. Most MBOs will deal with contact information of their members because that's how you're going to communicate with them and possibly pay them if you're a club and they're paid and you're paying them like a sports team, for instance, or their account information where they pay you if it's a paid membership organization, for example. If your members are children, so I'm thinking of those old sort of Mickey Mouse Club, Disney clubs that they used to have when I was a kid. I wasn't multiple kids. And so you could have children's personal information, you could have special personal information, being things like health or sex life, religious information. If you are a religious organization, the fact that you have members will probably give me as an external third party an idea of what that member's religion is. I doubt that there would be many people of one particular religion joining another particular religion's membership organization, for example. Similar to there was a similar example for sex life. If you are a trans activist or a sexuality activist of some kind, then you might be involved in a particular group like that, and it may give me, it doesn't necessarily give me, but it may give me some insight as to the health or sex life information of the particular member itself. So there's a lot of different kinds of information that you as an MBO will be dealing with, and you need to be aware of that to try and see if it's something worth protecting and what level it needs to be protected at. Other things to consider is, what are you generally protecting your members from, your data subjects from? And we've spoken about this in a number of different contexts before. Some for an MBO to be aware of would be annoying marketing communications. This is a big problem for a lot of different industries, but for member-based organizations, it could be quite dangerous. People are joining you because they're wanting to hear from you, but if you abuse that, it might undermine not only the data subject's sense of privacy and peace, but it might also undermine your activities as an organization. So how you deal with that is quite important. John, I see that you have your hand raised.
Kevin, just to back up on what you're saying, for me, the most important thing for a member-based organization to focus on is their members. That's why you exist. And yes, the employees are important and you want to protect them from harm, but it's really the members. And as an MBO, if you're not looking after your members, including their privacy, and if you're not doing that, and if you're being a nuisance to them, you're going to lose members. And I think it's challenging times at the moment for all MBOs, because many companies who were members of professional associations are reevaluating it and saying, times are tough, we don't have a lot of money, we're just not going to pay the subs to that association. So it's really important to look for ways that an MBO can add value to its members, and really make sure that the members feel that they can trust their association. And so for me, that's the primary focus.
Great, thank you. Yeah, and so that's why often when I talk about protecting people from harm, I link this idea of protecting people from harm to putting the customer first and the business case, because you're not only protecting the customer from harm, you're also kind of protecting yourself from harm, not necessarily just in the context of the potential fines or damages that you could receive if there was a breach, but the actual business harm of, if you're not looking after your customers, they're not going to be your customers for very long, which is exactly what John has mentioned. The other thing to consider from a harm perspective is things like we've spoken about the sensitivity surrounding the reason that they're a member. So for instance, if you follow a particular religion and you've joined a group of that particular religion. But also consider if you are a organization that exists to promote the ideas of a particular industry or a particular profession, and you have a significant number of stakeholders and they have particular thoughts about how this profession or this industry or this area is developing. Those thoughts, those communications, those engagements that you have with them could also be particularly important. So I don't want to name names here or anything, so let's use a completely fictional example of a member-based organization of South African wizards. We're in Harry Potter's universe right now, and South African wizards have the chance to decide whether or not they vote Voldemort in as Minister for Magic in South Africa. Now, if you have a particular aversion to that, and you say, no, I don't want Voldemort to because I think that he's a horrible, horrible person, what if that communication gets out? What if he now hears that you don't want him? That's very dangerous for you. So consider what it is that you as an MBO do for your members, what kind of information they have, how can you protect them? So that's harm, and that's the core reason as to why we're protecting personal information. From a member-based organization perspective, balance between information rights is it's important, but probably not the thing that you should be focusing on the most. The biggest thing for us to consider over here is that data protection law focuses on protecting personal information, but understands that information does have to flow. So it understands that you're going to be using that information, and you have to balance that flow versus the protection. And so you have to bear in mind that your members are going to be communicating with each other. They're going to be using you to get access to certain information. They may also be part of your organization to have other people contact them, say in a professional capacity. And what you're wanting to do is you're not wanting to undermine that reason for being, but you're wanting to take into account the certain elements that need to be kept confidential and protected. The other thing to bear in mind is, similar to this balance, is the global perspective. Data protection law does not exist in a vacuum. Data does not exist in a vacuum. Data has legs. It can go to a variety of different places. If you have members in South Africa, POPIA will apply to you. If you have members in the EU, GDPR will apply to you because you are processing the personal information of people in the EU. And so what you need to then be aware of is that you have a significant number of data protection laws that you will then have to weave your way through. And it's about trying to find a balance between what it is that you need to do and what it is that you practically can do. One of the benefits of data protection law, in our opinion, is that it is 80% the same. You don't really need to do too much more to hit the specific differences in a particular jurisdiction. So it's important for you to decide, where is it that I, as an organization, am based? And what is it that I need to do to cover the data protection laws that apply in that particular area? And is there a way to leverage off the similarities between one jurisdiction and another jurisdiction and put my main focus area in this particular common area. Similar to that, you should also consider whether or not there are any other laws that apply to your activities. If you're a MBO for a particular professional organization, are there perhaps laws that apply to that professional organization or industry that that affect the way that you process personal information? It's unlikely for this to occur because it would likely be that that law applies to the professionals themselves and not the entity that facilitates the communication or the engagement between those professionals, but it might well. And it's important to consider that because POPIA and many other data protection laws require that you apply POPIA as the default data protection law. But where another data protection law provides, or another law provides higher levels of protection for a data subject, you must default to that particular data protection regulation or law or provision. So weaving your way through these various laws is quite important. And understanding what you need to weave through is even more so.
Evan?
Yes, John.
Before we move on, Jason's asked a really interesting question in the context of balancing information rights. And I think it's worth tackling it while we're in this section. He's saying that they're registered as a non-profit company in the Companies Act, which makes sense. You can either be a common law association or a non-profit company registered under the Companies Act. And in terms of the Companies Act and its section 26, people can ask for various information from a non-profit. For example, they can ask for a register of the members of a non-profit. Now, obviously, the list of members of an organization or an MBO is often very confidential. It's a very sought after list because it's a pool of people with common interests. And so what you don't really want is you don't want somebody to be able to ask for that list and you've got to give it to everybody. And I think that it's a mistake that the Companies Act said that in terms of section 26, but it's a classic balancing information rights issue. Someone wants access to information, you don't want to give access. So as the company, you don't, but also the members probably don't want you to give out that list to various people because it could be used to infringe their privacy. So you end up with this scenario of balancing different people's interests and rights to information, and it's a classic issue. Combined with that would be the Promotion of Access to Information Act, or PIA. And I think that the way to tackle that, Jason, would be to look at the grounds for refusal in PIA and see if you can rely on those to refuse access and balance that with the Companies Act. And there are multiple grounds for refusal you could use there, but I would use the framework of PIA to deal with that situation.
I agree. I think one of the challenges here is that having not looked into it, so I can't say that I'm speaking from any position of 100% authority yet, but my gut would be looking at why would the Companies Act say that you can get access to the members list. It's likely from a perspective of if you have a non-profit organization, the reason that it exists is to not get profit, really, to be not necessarily a charitable organization, but it has a very different mindset from a for-profit organization. And so access to those members would likely be there to incentivize, or rather, to incentivize the adherence to that non-profit mindset. If you don't know who the members are, it might be that you could hide away and actually be doing something that you shouldn't be doing. But it's a broader discussion, and I agree that PIA would be likely the best area to look at for how to restrict that flow of information, if necessary. Okay, so moving on, the next step really for any organization is to identify your strategy and your readiness in applying data protection law. Now, there is a lot that we can say here, but I'm cognizant of time, and also I'm cognizant of the fact that this is very dependent on the size of your organization and the information that you process. The core considerations really is, as we mentioned before, you have to identify what is the impact of data protection law on you. What is the kind of information you process? What is the likely harm? What is the risk that you run in failing to protect data protection? Failing to protect personal information. Then it's about looking at how ready are you to engage with this? Do you need to get stakeholder engagement? Do you need to get sort of governing body involvement? For a lot of you, you won't need to because you're too small of an organization to even have a governing body. But if you are of a larger type of organization, you might need to have the correct mechanisms in place, the correct structures within your organization in place so that you can engage with data protection law sufficiently and efficiently. And then it's about identifying what your compliance and program strategies will be. Because as we say, there is a lot that you can do. You don't necessarily need to do all of it, but you must identify the path that you will travel. Are you going for absolute compliance with the law? Are you going for minimum compliance? And for smaller organizations, there's a lot less that you will need to worry about than large organizations. John, I see that your hand is raised.
Yeah, I think from a compliance strategy perspective, I would say, based on members being the most important, I would focus on the life cycle of members. So how do you get members? What do you do to get new members? Then how do you collect members' information? How do you store that information? How do you communicate with members? How do you allow members to participate? What do members log into? Can members see the personal data you have about them and correct it? That's where I would start, with that life cycle of membership. And for me, that would be the core.
Great, thank you. Okay, so that's the intro, and the core really for me in this webinar really is identifying the elements that are applicable to an MBO that change how it is that we look at this particular presentation. From a timeline perspective, there's not much to say over here. POPIA has commenced. If you're concerned about the GDPR, that commenced many years ago already. So the timeline is now. Now it's about making sure that we have everything in place so that if there is a breach, if there is a concern about data protection law, you have everything there. I'm not saying this to freak you out. I'm not saying it to scare you. It is a position that a lot of people are in. The deadline came and went, and a lot of people were left with a lot of stuff to do. There is still space for you to rectify it. No one is going to throw you in jail immediately, but we do have to do a little bit of damage control. In terms of the main understanding of what data protection law is, we have this general overview, and we look at what the facts are, what the core definitions are that we deal with in data protection law, who the role players are, and some rights and obligations that the parties have, and then the data protection principles that apply. So the relevant facts are that we're dealing with personal data. We're not dealing with all kinds of data. So any data that it can be used to personally identify someone, that is what we're concerned with. Data protection law applies to personal data, not to other data that cannot be used to identify people. Very important to be aware of is the special categories of personal data, the categories that are specifically referred to in Papier. So this is special personal data. That's things like your health or sex life, religious association, trade union membership, political persuasion, criminal behavior, things like that, things that can be used to very easily discriminate against people. Account numbers are important as well. Anything that gives you access to someone's funds or credit facilities is defined as an account number. And children's personal information. And that's really those are really the most important aspects of personal information that we're concerned about. And in a member-based organization, the information that you're likely going to be dealing with, as we've mentioned already, is contact information, account information, perhaps, definitely the interests of your members. That's after all the reason that they're joining you. It could possibly be their physical location if you are an area-based MBO. If you are a club that takes social media marketing pictures, for instance, if you're a tennis club and you have a tennis open day, and you're taking happy snaps of people as they're playing tennis, you could have photographs that go online, and that could show who's a member of your organization, even though people might not otherwise be able to access a membership list, for instance. We've spoken about the stakeholder engagements. If you're a professional association, you may have education information, marks and degrees that people have earned. Some of this might be important for you to be able to share publicly. Others, it might just be for you to know so that you can vet that these people are who they say they are, but it's not information that you want or your members want to have shared publicly. And then it's important to consider the special personal data, if any, that you process as well. Like we mentioned before, you might have members who are children, and you might have members who are of a particular religious persuasion. You might also have members who are ex-cons if your MBO focuses on sort of upliftment of previous criminals, things like that. In terms of role players, the general...
Sorry to interject there. Here is some questions actually related to that. Someone asked whether they need to have an agreement with their beneficiaries to use their personal data in like a report. And then also maybe you can share steps they can do to protect the data, the personal information that you just mentioned, like just maybe 1 or 2 steps.
Okay, so in terms of protecting the information, it really depends on what the particular activity is that you're doing. If you're simply storing the information, then it would be, I suppose, sufficient and reasonable to store it in a secure location. Are you storing it in hard copy files? Are you storing it electronically? If you're storing it electronically or in hard copy, really, who has access to that? If it's particularly sensitive information, you might want to make sure that if it's stored electronically, you encrypt that information. There really are a large number of things that you can do to protect that information. If it is communications that you're engaging with, what are those communication mechanisms that you have? If you are getting people's sensitive information when they're signing up, is the portal that they sign up online, is it secure? If they're sending you an email, who has access to that email address or account? And do people know that if they were to hack that email channel, they would be able to get access to all sorts of juicy bits of information about people? So consider, how are you storing the information? Consider what are the channels that you're using to get the information, and who has access to that information. Those are some of the very easy things that you should be thinking about first off. And then Jade, I'm sorry, I've forgotten the question regarding the report, the first question that you asked.
Thank you. Given those tips were very practical, I do see John has his hand up. I think it's related to what you were talking about. Maybe John, you want to, before
Yes.
I go on to the next question?
Sure, yeah, the question was about whether you can share beneficiary details in a report. And I see Marty's also asked a question about sharing personal, so how do we go about protecting personal information in court reports? And both of them, for me, relate to a principle that data protection law knows and acknowledges that there still needs to be a free flow of information. In other words, we can't stop personal information being used altogether. It has to be used. And so it is going to be in court reports. It is going to be in other reports, and beneficiary details will be there. And there often are good reasons for them being there. But I think we've obviously got to take it, not just data protection, but privacy and confidentiality into account. And where possible, we want to approach people and check that they're happy to be named or included. So definitely with beneficiaries, if if you can access them, then it would be to ask for their consent. And that consent can be done through the mechanism of a privacy policy. And certainly, I think all of you should have a privacy policy that relates to your members, which simply sets out what you can and can't do relating to their personal information. Yeah, so that's my thoughts there.
Great, thank you, John. I also see that there's a question regarding the interplay between personal information and confidential information. Pranisha has asked, and I think you touched on it a little bit in your answer there. But from my side, I would add that there is an overlap between personal information and confidential information. Sometimes it's not that one is a subcategory of the other. I see it more as a Venn diagram where there may well be a overlap somewhere in the middle. Answering exactly how you can sort of create a schism between the two, how you can divorce the two, that's not a particularly easy question. I think it might be a little bit too much to say that personal information is inherently confidential information because of the way that companies deal in terms of contracts, at least, with confidential information, saying that you can't share it without permission or unless in XYZ circumstances. And in my experience, those circumstances there, the way that we deal with confidential information heavily restricts the freedoms that data protection law give us, the ability for data to flow that data protection law anticipates. So if you were to treat personal information as confidential inherently, that would really hamstring your abilities to process personal information in a way that is lawful and that data protection law regards as being fine. Okay, so in terms of role players, the standard breakdown of role players is the controller, who, or in South Africa, regarded as the responsible party. This is the person who determines the why and the how of processing the personal information. For MBOs, you will largely be the responsible party or the controller for most of your activities. The processor is an external third party who falls under the control of the controller or the responsible party. In South Africa, the processor is referred to as an operator. They actually do the processing of the personal information on behalf of the controller. So in an MBO context, this might be a mass mailer or a mailing client that you use to communicate with your members. It could be a web host or software as a service provider that you use to store the information or manage the website that you collect and process personal information through. And then the data subject is very clearly the person about whom the information relates. And the important thing to bear in mind in this context is that the role player changes depending on the activity. It's not just because you are a company, just because you are an MBO, you will always be the data controller. You might, in certain instances, be the data subject. You might, in certain instances, be a processor on behalf of another controller. But as I said, it is likely that in the main activities that you perform, you will likely be the data controller. And I see John in the chat has shown that controller equals responsible party, processor equals operator. They're synonyms. They're just different terms used in different jurisdictions.
John also has this. Okay.
So just to pick up on Nicole's question in the chat box there, I would say that they're not an operator for each other. If one controller shares information with another controller, but they've got separate purposes, even though one's collecting and providing to the other, there's a good chance that they're separate controllers and not a processor for each other.
Great, thank you, John. Okay, and then we won't speak too much about rights and obligations over here. The reality is that data subjects have certain rights, and you as a controller or a processor have the obligation to try and give effect to those rights. These rights include knowing that information is being processed, accessing that information, rectifying, erasing, restricting, objecting to the personal information, and not having any automated decisions being made about them. From an MBO perspective, it might be important to consider your data subject's ability to object to the processing of their personal information, particularly if it comes in the form of marketing communications. Can they opt out from the marketing? That doesn't necessarily mean that if you are sending them admin messages that are necessary and not necessarily providing you with marketing communications, that you need to provide them with an opt-out there. You don't need to do that. If it's an admin message, if it's necessary, then you can communicate. The right to objection mainly relates to things like direct marketing. It can potentially relate to other forms of processing as well. But the core really is understanding whether or not this processing is necessary for the purposes that you've described. For MBOs, it also may be relevant to consider whether or not there are any automated decisions that are being made as to who is a member. If you are a club, for instance, and you are doing disciplinary hearings, perhaps you are an esports group and you've received complaints about certain of your members who are trolling others. Do you have automated means of kicking people out or suspending them? Data subjects have the right to not have automated decisions be made out of them. And this really is the core of this, is that the decision mustn't solely be made automatically. There must be a person on the other end of the line who can review it, and that there must be suitable measures in place to ensure that a data subject's rights are not negatively affected by the automatic processing. Similar to data subjects having rights, you as a controller or a processor have certain obligations. There are significant ones, including keeping records of your processing activities, securing that personal data, and cooperating with authorities. The core really for you here, regardless of the size of your organization, is in South Africa appointing an information officer. If you are in the EU, you may need to appoint a data protection officer. It's not particularly likely unless you process significant quantities of personal information. But you may well need to appoint a representative within the EU, which essentially acts as your human postbox for the EU data protection authorities to communicate with your organization that isn't necessarily based in the EU. And then the core data protection principles that you have really are that you have to, in order to process data protection, in order to process personal information lawfully, you have to have a lawful ground to process the information. You have to do the processing fairly and transparently. You have to process the information for a particular purpose that you disclose. So this is often where privacy policies come into play, to say this is why I'm processing your personal information. You must only process the personal information that is necessary. If you are a member-based organization that, let's say, I used an esports club, for instance. If you have your team members that have joined, do you need to know their sexual orientation? Probably not. If you're a member-based organization that is specifically for gays and lesbians, then maybe you do need to know their sexual orientation. So is that information particularly necessary? Are you processing the information accurately? Has the data subject got the ability to actually communicate with you and say, no, you've got my information incorrect? Because there's possibly harm that can come from having incorrect information. You should only process data as long as is necessary. If someone has left your organization 50 years ago, they have no intention of rejoining, and you still have their information, why do you have that information? Is it necessary for you to have that information? If not, data protection law says that you should get rid of it. And then the final data protection principle is that idea of security, processing personal information security, applying reasonable technological and organizational measures to that particular activity that you do, whether that activity is storing, whether that activity is communicating with people, or sharing the information. Are you doing it securely? A lot of people think that data protection law is entirely this particular principle of security, and that as soon as you have a encryption software or particular firewall in place, that is all that you need to do. That's not true. You have to pay attention to all of these other principles as well. The other very important thing to bear in mind is that when considering these principles, you also have to consider the type of personal information you're dealing with. So if you're dealing with general personal information, like my contact information or the address that I stay at, there you do need to find out whether or not you have lawful grounds on processing this personal information. But when you are dealing with things that are more sensitive, like children's personal information or special personal information like sexual orientation or religious affiliation, there other additional factors come into play, and you need to make sure that you check those off and that you have lawful grounds there as well. So that really is just a blitz through the overview. Now we don't have much time to go through the plan and protect stages, but there isn't really much for us to do here because of the wide range of member-based organizations and the different industries that you play in. I see on the chat that there are a lot of non-profit organizations here, and that was expected. There is a significant overlap between NPOs and MBOs, and we do have a lens and a webinar on non-profit organizations as well that you're welcome to have a look at for a little bit more particular guidance. From an MBO perspective, it's unlikely, as we mentioned before, that governance and software would be applicable to you if you're a small organization. So you don't really need to look too much at that. But depending on the size, if you process a significant amount of personal information, if you have a significant budget, if it's very risky to you, then data protection software would be very useful in managing the way that you process personal information and how you can do so efficiently. Likewise, if you're a larger organization, you should make sure that your governing body is on board and that you've got governance rights within your organization as to how your employees are aware of data protection law, how they process personal information in their day-to-day activities. A lot of people ask us to do gap analyses as one of the first things that we do when they ask us to come on board. And we think, and this is why we've put it so far into the planning stage, we think that that's a bit premature, that you really need to start with considering all of these other factors, principal amongst which is mapping your activities. Identify where you process that personal information. I've spoken a lot today about the kind of information that you process, but the activity that you engage in, the storage, the transfer, the communication, each one of those instances of processing, that you need to identify. You need to say, this is how I'm processing it. This is how my processing affects data subjects, and who is getting access to that information. Once you've done that, you can then start considering what the gaps are, applying the particular principles that we've just spoken about to the activities that you're engaging in. And you realize, actually, wait, when I'm communicating to people, I'm communicating in a very insecure manner. And I'm actually sharing a significant amount of delicate personal information with a large number of people. I'm CCing people on emails rather than BCCing them, so everyone can see who else is a member of my organization. That's a way of applying the principles to a particular activity, and through that, identifying what the gap is. We have come up with a significant number of quick wins and actions to take first that you can look at in the program. These are things that a large number of organizations have done as the first steps, the things that they do when they want to hit the ground running, to get a significant amount of actions under their belts and get further down the road in terms of their data protection project. And then on the protect stage, same, depending on the organization focus areas, there are a number of different things that you could be doing. From a general MBO perspective, some of the core instances would be appointing your information officer, registering them with the South African Information Regulator if you're based in South Africa. Potentially appointing a representative if you have tendrils in the EU but are not necessarily processing a significant amount. If you are processing a significant amount, you may need to appoint a data protection officer in the EU. And then, because you're communicating with your members a lot, marketing and sales is a very important aspect that you should consider as well. The core of this in terms of data protection law is that we've shifted from an opt-out mode to an opt-in mode in South Africa. And this graph will show you really the breakdown of how you can deal with your communications. So if you are marketing to a prospect, someone you don't know, it is very much an opt-in mechanism now if you are communicating with them electronically or by digital means. If you're doing physical or non-digital communications, so this would be a person-to-person telephone call in our interpretation of it, and very definitely things like paper-based mails or coming up to someone on the side of the road. These are opt-out. You can still do that perfectly. If someone says, I don't want to receive these communications, then you must stop. If someone is a customer of yours, then there is what we refer to as a soft opt-in. By virtue of the fact that they are a customer of yours, you don't need to get their consent to market to them. You already have their consent because they're a customer of yours. There it is opt-out. The important thing here is that the idea of what a customer is quite broad in data protection law. Under POPIA, it is defined as anyone whose contact information you have acquired by means of in the context of an offer for goods or services. So this would very much be a member in your organization. You are providing certain services to your members. They are your customers. Whether or not they pay you to be a member is completely irrelevant. you are providing them with goods or services. They are a customer from the perspective of data protection law, and you can then market to them. And that really is the core that we have to focus on from a member-based organization perspective. We have 2 minutes remaining. Kevin, if I could, anything that you would like to add?
Yes, I think just in terms of some quick wins for MBOs, some of the things I would suggest you do is that you need a PIE manual by the end of the year. 1st of January is the deadline. I think you should all be exempt, but the regulator has said that you're not. So you need a PIE manual, and you need to put it on your website, because otherwise it's a criminal offense. Then you need to register your information officer. And Reynard makes a great point that the regulator, their systems are not working, but try and register them on the portal. If you can't, email them, and that's an important thing to get done. And then many of you will have special personal information or children's information, and check that the law authorizes you to process that. Then I think few of you will need to get prior authorization, but if you're profiling your members, then you do. And the deadline for that is the 5th of October. And so that's an important thing to think about. Picking up on what Kevin's saying about the opt-in regime, you must use a mass mailer to send out bulk communications to your members. That's very, very important. And then I would also focus on who are your major operators. So who processes personal information for you, and enter into a data processing agreement with them to make sure that they secure the member information that you have. And then, yeah, focus on some practical information security things. Make sure all your employees use a password manager. Have discussions with them around, have they encrypted their devices? Are they applying normal standard information security measures to protect their devices? And so for me, that's a list of 5 or 6 things that you could get cracking with immediately. And there's obviously a lot more to do, but those would be some of my quick wins. Back to you, Kevin.
Great stuff. Thank you very much, John. And then I see a question from Mari in the chat saying, if you have photos and videos of club members that you'd like to use as a marketing tool, is it sufficient to have permission from members to use this information? So this goes back to the principles of data protection law and the question of lawfulness. Do you have a lawful ground in terms of which you can process this personal information? And consent is one of those lawful grounds. You don't always need consent to process personal information. There are other grounds that you can use, but you must, if you use any of those grounds, be it consent or any of the others, you must do so in conjunction with all of the other principles, and bearing in mind all of the other rights and obligations that you have. So for instance, if someone has given you consent but then later objects to that processing, then you should take that into account and stop processing that information based on their consent. And John makes a good point. You may need a photo consent policy. This is something that we see schools requiring. In a school's context, it's a little bit different because you're processing information of children, and their consent is much more valuable, much more important, and may well be if you have members who are children in your MBO. So yeah, there's a lot to consider in data protection law for MBOs. We really have just skimmed the surface. I hope that you have found some good value in what we've discussed today. And John Jaudet, if there's anything more from you, I think that about wraps it up for me. Is there anything you'd like to add?
Jaudet, are there any other questions that you think we should tackle before we sign off?
You did address the question about the information regulator, but Susan just asked another question about the portal. It says that it's out of order and they're getting an email return with not read notice. Do you know if there is a different portal regarding profiling, or will there be something else later on? Or do we just need to wait for the information regulator?
Yeah, we basically need to wait for them. I mean, that's there's only one of them and they're it. And there's nobody else that we could go to ask. So keep a record, though, of what you've tried to do so that if anyone ever challenges you, you'd be able to show and say to them, no, look, we tried to do A, B, and C. So definitely keep a record of what you tried to do. But it is frustrating. The regulator at the moment, their systems aren't great. Their guidance notes aren't great. They're not really supporting and helping people to comply with these laws in a meaningful way.
Thank you, John. There's a lot of thanks from everyone. Thank you both, John, and thank you, Kevin, for the wonderful webinar.
Great stuff. Thank you very much, everyone, for attending. I really appreciate it. And we hope to see you soon.
Great. Thanks very much.
Cheers.